So in this video, we're going to talk about what happens to your house in a divorce. You know, when folks are coming to us, usually one of the number one questions that they have is, what will happen to my house in a divorce? If you think about it from an emotional perspective, your house is where you've raised your family. It's where you've raised your kids. It's where you spend a significant amount of time of your marriage. It's going to have a huge emotional impact on the divorce. If you think about it financially, a lot of folks are coming to us and a vast majority, if not the entire estate, is tied up in the house. So what happens to the house in a divorce is usually the number one question in a divorce. Folks also want to know what is going to happen to the house while the divorce is pending. Are we going to have to live in the same house together? Are we both moving out? Is it getting sold? What's going to happen? And we'll address all that in this video. Before we get into those topics, know that in a divorce, when deciding what to happen with a house, we have to decide, or we have to determine, is the house community, is it separate, or is it of mixed character? And that's something we can address in another video. And we're also going to address, is there a reimbursement claim on the house? Are there other factors that we have to decide in the property division when we're talking about the house? Now let's talk about, though, what happens to the house when the divorce is pending. This is a huge question that our clients have when they come to us, because obviously majority of our clients do not want to spend the divorce living with their spouse. Now there are some instances, I will say, when folks come in and they can by agreement live in the same house while the divorce is pending. That is extremely rare, and it's something we advise against because it's just not the position that you want to place yourself in or place your kids in what is already a stressful time. And frankly, if you go to court and you can't agree, a judge is not going to leave both parents or both spouses in the house while divorce is pending. So let's talk about that. What happens to the house while the divorce is pending? Y'all aren't going to be living in the same house together. You're going through a divorce, so who moves out and who stays in the house? A lot of times people agree. You know, the husband will decide, I'm going to go get a condo or I'm going to go get an apartment. If he's got kids, then I'm going to get a place where the kids can come and visit. Or if the kids are living primarily with the husband, I'm going to get a place that's in the kids' same school zone where they continue to go to the same school and they can live with me primarily. Or it could be vice versa. The spouse moves out, the wife moves out, the kids move out with her, or they stay in the house, the parents work out a visitation schedule by agreement, and it all goes smoothly by agreement. But practically speaking, a lot of times people can't agree on who moves out of the house, or they can't agree where the kids live primarily, and so that affects who moves out of the house. And so they have to have a judge decide that. So when a divorce gets filed, one of the first things that gets resolved is temporary orders. And we could talk a lot about temporary orders, and we do in other videos and other parts about the website. Temporary orders is where a judge is going to decide what are the ground rules while the divorce is pending. So we're talking about possession of the kids, we're talking about where the kids live primarily, how support's paid, what bills are paid, how we exchange information. All that and more gets addressed in temporary orders. But one of the main things about temporary orders that we'll talk about in this video is what happens to that house. So if you're a judge and folks are coming to you and saying, we can't agree on what happens to the house while the divorce is pending, you got to decide who moves out and who stays in the house and under what conditions. So if you're thinking about it from a judge's perspective, your number one thing that you're going to be considering is, where are these kids going to live if the parties have kids. So let's say the kids live in the house and it's in a particular school zone. If you're a judge, most of the time, you're probably not going to want to disrupt the kids while the divorce is pending. So you're going to be inclined to want to keep the kids in their same house, same school zone, so there's the least amount of disruption for the kids. That's often the factor. Not always, but that's often a controlling factor for the judge. So then you're deciding, okay, which parent do the kids live with primarily? If it's mom, then I'm going to have mom stay in the house. If it's dad, then I'm going to have dad stay in the house. And then I'm going to make arrangements for the other spouse to move out and have the children visit that spouse under the possession schedule that the court decides. That's typically the controlling factor. Now, if the folks don't have kids, then the judge, as the judge, you're thinking, okay, practically speaking, who can stay in this house and pay for the bills, and who am I going to move out of the house and is more likely to live out of the house on a permanent basis? Because I don't want to do one thing on temporary orders and then at final orders do something completely different and folks are playing switcheroo with the house. That can also be an important controlling factor of what am I going to do on final trial most likely with this house, and so I'm going to do the same thing on temporary orders, so there's not a bunch of back and forth. That's something that a judge can consider. The judge may also consider who can afford to move out, or who, practically speaking, is going to be better situated to move out. All these types of things weigh on a judge when they're deciding who lives in the house while the divorce is pending and who moves out. And the judge is going to consider all the factors that you present to the judge when deciding who lives in the house and moving out. Just know that the children, where the children live, that's most likely going to be the most controlling thing about who lives in the house and who moves out. Now, once a judge orders somebody to move out, you're going to have to address, where does that spouse live? How does it get paid for? And that's something else that gets addressed in temporary orders. So the judge would be deciding, okay, this spouse is moving out. I'm going to authorize him or her to spend X amount of dollars on renting a piece of property. Or I'm going to authorize this much community money to get spent on a down payment. Or if that spouse can afford it based on his or her own salary, I'm just going to tell that spouse they've got to move out and find their own spot and figure it out. They may also be telling the spouse that stays in the house to pay the mortgage, or if the spouse staying in the house can't pay the mortgage, they could even pay the spouse that's moved out to pay the mortgage. So for example, if the wife's staying in the house and she's been a stay-at-home mom and she can't afford the mortgage, the court may very well order the husband on temporary orders, hey, you move out, and even though you're paying your own place, you still got to pay the mortgage for your wife to live with the kids, or vice versa. When you think about it, there's all sorts of arrangements the judge can do when deciding what to do with the house while the divorce is pending, and how to set it up financially and set it up for the kids. Pretty much everything's on the table, but just know that somebody's probably going to be moving out, and the kids are going to live probably in the marital home. Now, another thing that gets decided on temporary orders that a lot of people will either agree to or have a minimal dispute about is placing the house on the market. If you're thinking about a divorce and you think about it practically speaking, if most of our marital estate is tied up in this house, and frankly, neither one of us want the house at the end of the day, or we bought this house thinking we're going to be living together and we're going to have our kids, and so it's way more house than any of us need individually, these folks are going to be thinking about, okay, we need to sell the house. If we're not going to be living together, if most of our money is tied up in that house, let's get it on the market and get it sold. So a lot of times we'll be working out with the other side, placing the house on the market, getting agreed upon realtor, and getting the house on the market as soon as possible so we can get offers on it and figure out the house is going to be sold before the divorce. Now, sometimes people don't want to put the house on the market. Sometimes they don't agree and they both decide that one spouse is going to get the house at the end of it, so let's not place it on the market. Or sometimes one spouse will want to sell the house, the other spouse doesn't want to sell it, and a judge will have to decide, are we going to place this house on the market while the case is pending? They don't have to do that. The judges don't have to place it on the market. A lot of times they do if we're thinking that the house is going to get sold at the end of the divorce anyway. Let's go ahead and get it on the market, get the ball rolling, and then decide the terms of sale. And then the same thing, decide who's going to live in the house while the house is pending for sale and who's going to move out. So that's temporary orders. That's just a little scratch on all the things that the judge can do on temporary orders with the house. Let's think about overall what happens with the house at the end of the divorce. And remember, there's that discussion for a different video and different parts of the website that talk about whether or not the house is community, or if it's separate, or if it's a mixed character, or there reimbursement claims. All that's got to get figured out when you're thinking about what to do with the house. But let's also think about just a simple example of the house being completely community property. And let's say we all agree it's community property, so it's got to get divided. It doesn't necessarily mean that the judge has got to, divide the house just straight in half. They're not going to do that. It doesn't necessarily mean that the house is going to get sold and the proceeds are going to get split. That's the easiest way to do it. If all you've got is a house, and we're all agreeing to split the estate half and half, you sell the house and you split the proceeds half and half. And if one spouse has had to pay for the mortgage while the divorce is pending, and the other spouse, has kind of gone the free ride on it, you can allocate that whenever you sell the house. That's the easiest way to do it. But what happens if, let's say, one spouse wants to keep the house at the end of the divorce, or we're all agreeing that one spouse keeps the house at the end of the divorce, or say it's of mixed character and it's part the husband's separate property and part community, so it's going to go to him, but we just got to figure out what the value is. Because if an asset is going to go all to one spouse, 100% to one spouse, you either got to buy out the other spouse for his or her share of the equity, or you have to push assets, other marital assets, to that spouse to compensate him or her for that spouse getting the house. So when you think about it, practically speaking, that means that we got to figure out how much this house is worth. Because if, let's say, the wife is keeping the house, well, okay, so what value is she getting for keeping in that house? And if she's getting that value, how are we going to compensate the husband for that value that the wife is getting? So you got that big question mark of what's the house worth? Now, if you're selling the house, the question of what the house is worth is what somebody's going to pay for it. It's just what the market pays for it. But again, one person keeping that house, we got to figure out what's it worth. So folks come to us all the time and say, okay, well, we'll just look at the county appraisal district. I live in Travis County, let's look in the Travis County appraisal district. I live in Harris County, we'll look at the Harris County appraisal district. You know, that can be a guide for how much your house is worth, but frankly, it's not determinative. When you think about how those appraisals are done, those are done in mass with comps, and they actually aren't an individual appraiser. So some would argue, and I would argue, that those aren't even admissible in court of what the appraisal district says your house is worth. You're more than welcome to, by agreement between the two spouses, say that's what we're going to look at, but it's really not the proper way to sell it, to value a house in a divorce. Folks also come to me all the time and say, well, we have a realtor that did a CMA for us, and they think that the market analysis says that the house is worth $600,000. Okay, that's helpful to know what the realtor says, but a CMA is not really the way a house is valued in a divorce. A CMA is just the realtor saying this is what we should put the house on the market for. The realtor may be motivated to put it up high. Plus, frankly, it's not necessarily what the house is worth. It's just what we're going to be asking for. So to really do it, if you're preparing for court and going to have a contested divorce trial where y'all can't agree on the value of a house, or you want the information so you can try to agree, but you want the actual valuation that would be used in court, the real way to do it is we go get real appraisers to do an individual appraisal of the house. So a lot of times people will do a joint appraisal. So they'll find somebody that both sides respect and ask him or her to go do an appraisal for the house. And then once we get that appraisal back, we'll agree to use that appraisal in the divorce. Sometimes people cannot agree on the value, cannot agree on the appraiser. They say, well, you go get your appraiser and I'm gonna go get my appraiser. And then you've got two competing numbers in the divorce. So you think about, as far as litigation is concerned, that can really drive your litigation if one appraiser comes out and has a wildly different number than what the other appraiser does. It can be a significant difference in the divorce. Because again, we're trying to figure out if we're giving this spouse the asset, we got to compensate this spouse for the equity in that asset. And what that equity is may be determined by an appraiser. And if there's differing opinions, you got something to fight about in court, and a judge is going to have to decide, if you can't decide by agreement, what the appraisal of the house, what the value of the house is through the appraisals, and then do all that math of how do we compensate the other spouse. So it can be a significant dispute in a divorce of what the actual appraisal of a piece of property is. Again, a lot of times people are either selling the house, so it's a non-issue, or they're coming up with a joint appraiser. But we certainly have had situations where we're having to put appraisers on the witness stand, do cross-examination, and talk about why this number is significantly different than this number, and why a judge should listen to our number versus the number from the other appraiser. So that's what we're talking about overall whenever we divide up the house and award it to one spouse or sell it, how we deal with that. So then logistics, let's just talk about logistics, what happens with the divorce. Because when you think about a house, a lot of times the deed is in both spouses' name. A lot of times the mortgage is in both spouses' name. So let's say the wife's getting the house at the end of it, but the husband's name is on the deed. You got to get that cleaned up. So what's done in a divorce is a document called a special warranty deed that gets signed by the spouse who's not getting the house. He or she signs that deed over to the spouse that got the house, and that'll get the title just in the spouse's name that got the house. That's a relatively simple process that we do routinely in the law office. What's a little bit more, not necessarily complicated, but more important to folks is what do you do about that note? Because if you think about it, if my spouse is getting the house, but the note's in my name too, I want my name off that note. I don't want my credit report having a mortgage on it that for a house that was awarded to my spouse. And in fact, some creditors, when you're applying for a new mortgage for a new house, they may look at it and say, well, you're already on this mortgage. I don't care that your spouse has the house. What I care about is that you're liable on this mortgage, and so I'm not going to give you as good of a loan or any loan at all because you're on this other mortgage. So that's a significant issue when you think about it moving forward if you're stuck on this note for a house that you don't even own. So folks ask me a lot, well, can't you just get a court order that says I get removed from the note? Well, you actually can't. The judge doesn't have jurisdiction or the authority to order the lender to take you off the note. The lender's not affected by your divorce decree. In fact, the family code says that third-party creditors aren't affected by the divorce. So it's really up to you and your spouse to deal with the mortgage company to get you off that note or get your spouse off that note if you're the one that got the house. A lot of times judges will order that the person that got the house, that he or she is ordered to refinance the house and get that other spouse off the note. And a lot of times what you'll see is in a divorce decree, a judge will say, you've got 6 months to refinance the house. You've got a year to refinance the house. And if you don't refinance the house and get that other spouse off the note, then you got to sell the house and the note will be extinguished that way. That's not an uncommon way to approach it in court. Another thing that we do is we do a document called a deed of trust to secure assumption. And what a deed of trust to secure assumption does is essentially the person, the spouse that gets the house and is assuming that mortgage signs this deed which says I'm going to be responsible for this mortgage. I'm going to pay this mortgage for the house that I'm getting, even though you're still on the mortgage, I'm assuming the liability. And the deed says that if I don't pay it, so if I don't pay the mortgage for the house that I got and it's affecting your credit to my ex-spouse, the ex-spouse can come in and foreclose on the house to protect his or her credit. So that's another way to protect spouses that are not getting the house in the divorce but are still stuck on the note. So I know that's a lot when you're thinking about what happens to the divorce, what happens to your house in a divorce. It's a lot of information. We have more of it on our website. But just know that it's a process that is routine for us, but it does need to be handled by experts who have done this before. There as you can imagine, lots of ways to mess up how to handle a house in a divorce. And given how significant that asset is, it's extremely important to consult with a lawyer when doing this process and to consult with a lawyer who has experience in dealing with houses in a divorce. And that experience needs to range all the way from litigating over what happens to a divorce, whatever happens to our house while divorce is pending, litigating on that issue, all the way to litigating what the value of a house is and who gets awarded the house in a divorce. So find a lawyer that has that range of experience if you are going to have a dispute in your divorce, and hire a lawyer who has the experience of actually going through the logistics of what happens to your home in a divorce. If you need more information on it, of course, you can contact us. There's other videos and parts on our website that address this. And of course, we're always here to help you in any way that we can.